2022. And the first bill up for discussion is H551. We may mark up the bill, but there will not be a vote today. We may want to hear from more witnesses. And Mark Hughes is with us, but not necessarily to testify, but certainly welcome his input. Not formal. So with that, try to make sense of where we're at. Many of us have spoken with various individuals concerned about possible unintended consequences of this bill, both from something that I know little about, and that's from deeds and how you can upset things, doing stuff piecemeal. And the second is concerns expressed by several individuals regarding the impact of this bill. I'll get the term right. It might remove the legacy of redlining and also the significant wealth disparity between minority populations and basically white populations, I would guess, because most of the deeds, at least in Vermont, appear to bar anyone other than whites from possessing property. Some of them had religious covenants also. So and that's the concern. I kind of got thinking about this over the weekend. I did have the opportunity to spend the time between Wallingford and Bennington with Mark Hughes on Friday afternoon, which an interesting way to drive. By the way, it was hands-free. Anybody who's listening in thinks it wasn't. It's all hands-free. And we had the opportunity to call each other back when cell phone disappeared, cell phone service. So I'm thinking that we may want to change this bill to one that looks at this from that perspective that I just outlined. Number one, what's the impact on BIPOC populations? Would it remove the legacy by doing this? And shouldn't we just ask, for example, the Vermont Bar Association perhaps, and the Director of Racial Equity or some other group to take a look at this issue and write the rest of the bill? So maybe we can get some thoughts on that from other committee members, or perhaps Mark Hughes, and I see Dan Richardson's here. I think Dan's representing either the city of Burlington or the Bar Association. I'm not sure which. Also, Senator Nitka, whose husband does a lot of title research, was concerned from another vantage point about this bill. Senator
Speaking for myself, I would love to hear just, if informally, some sort of testimony from Dan Richardson and Mark before we go any further.
Okay.
The other issue I want to mention is, you remember years ago we had a bill, there was a situation with regard to the banks were having trouble with us. We had something going on that it made it look risky for banks to loan to Vermonters.
Oh, it's the old roads thing,
The old roads thing,
the ancient roads.
ancient roads. And wasn't there another one also? There's definitely ancient roads. And
I
there was
don't
something
remember
else I remember vaguely, some other one where we had a problem that the case had a name.
Bianchi.
Yes, Bianchi, that's
It was Bianchi. Yeah.
Bianchi.
And
That's
what
right.
was that? What was the issue there?
The issue was that whether or not a property's failure to comply with permitting requirements that didn't have the necessary permits would create an invalid title, so that the title would no longer be marketable, wouldn't be marketable title. So I believe the bill that the legislature passed, and again, this is purely off the top of my head from memory, so it's probably wrong in a variety of ways. But I recall the bill calling, I think it was called the Marketable Title Act. And you did that in response to the Bianchi Supreme Court decision that said that
Right.
unresolved failure to comply with permitting was a cloud on title, and it made it unmarketable title, and title insurance companies wouldn't insure title on the property. So it clarified that in legislation. And I think you committee may recall that I mentioned earlier in my testimony that the title insurance companies were concerned with the prior draft of this bill. The language was redrafted when it was in the House, and the title insurance companies then agreed to it and said that the way it was drafted now would not present an issue for title.
Good recollection.
Senator Bennett.
Eric, it seems like we're overcomplicating this, at least to me. We know these covenants and deed restrictions exist. We also don't want them to be created in the future. Why don't we just simply declare any existing ones null and void and prohibit the introduction of any new ones in the future?
I think that's what subsection A and B do.
Yeah.
Well, I'm looking first at the legislative intent language. The other body loves to have lots of findings
Yeah.
that often leave people scratching their heads. Just getting right to the point, this act prohibits racially and religiously restrictive covenants from ever being used in Vermont again. And then it establishes the process for their removal, but the process for removal creates another document. And I'm wondering why that's necessary. Because even if you put another document into the land records chain, it doesn't physically remove the previous language that was offensive.
But you don't want to remove it, right, for historic purposes.
But it does make an expression of the owner's disavowal, which I think is moved legally, but it's clearly the drive behind that whole piece is to, somebody comes up for an appointment for a judge, they search their deed and they say, oh, you have one of these covenants, he's suspect.
So what does that say, though, about those who don't file such a document?
Well, and it's, as I read the intention of the bill, it was to allow people to kind of progressively self-report that they have one of these and that they disavow them, and that would increase year by year. But I think that's where the problematic part of the bill comes from, is that attempt to add to the record in the way that you're talking about. It creates another document. As I understood Mark's objection, it muddies the record as opposed to clarifying where all the deeds are, what the history of them was.
The problem that I've got is that most people have no idea whether they've got one of these on their records or not. A title search is only done for 40 years into the past. And at that point, the record search is cut off. A lot of these deeds predate that 40-year time period, but they are incorporated by reference into every subsequent deed. So to me, unless you are literally going back 200 years to search your entire chain of title, there's a strong possibility you have no idea that there's even one.
Yeah.
So I thought that what this did was allow you to say, if it is back there somewhere.
But shouldn't we as a society say that and declare it in statute, as opposed to trusting that individual title owners are
Oh,
going
just to
to
say
file
that,
a
just
document.
to say that from now on,
Yeah,
they
it's
won't be.
done. It just seems
Well, that's
more.
what the
Yeah.
intent says, but the bill doesn't do it.
I'm okay with it.
Do you want to comment on that, Dan Richardson, on some of the things you might have heard so far? And could we be clear of who you're representing in this particular, I know you're the city attorney for the city of Burlington, so.
Sure, I was contacted by Terry Corsones to make any statement necessary on behalf of the Bar Association, but I can answer that. So I'm here in my capacity as city attorney, but I can answer your question, Senator Benning. I think along the lines of what the bill was intended to do, and there are three parts of this bill. The first two sections, as Eric pointed out, really are both a retrospective and a prospective nullification of these type of covenants. It simply says any of those covenants that are in the land records currently are void as a matter of law. And then the second part says it's illegal to put them in going forward. And so that has that legal effect that I think you're looking for, Senator Benning, as far as just simply from a legal point of view. This doesn't actually take effect on any paper. It doesn't change any land records. It just simply says as a matter of law, these covenants are illegal or void if they exist. The release language is really from a chain of title perspective to give individuals the ability to cut off these covenants, because we can say that a covenant is of no legal effect, but it is still sitting there within the chain of title. And the release is just that additional opportunity to say, I hereby release. And as you point out correctly, Senator Benning, most of these covenants that as they exist, and I think you heard from Jim Knapp, a First American Title, most of these covenants, if they exist in the land records, are going to be beyond the 40-year marketable title. They're going to sit anywhere, there was a number created between in the 1920s and as late as the early 50s, when when Shelley versus Kramer and its progeny started to slowly stop that practice. And then eventually, of course, with the Fair Housing Act, when the federal government turned against it formally for federally mortgage-backed security purchases. But there are others that may predate that. There may be some from the 1880s. There may be some from, earlier. Those are the outliers. And I think the idea of having this as a voluntary document has two purposes. One is it gives landowners the opportunity when it arises. And practically speaking, the opportunity is going to be when people sell property, because that's when they have title attorneys that are going through looking at the chain of title. And this release in some ways gives an incentive to people to say, look a little bit further back. If you come across one of these covenants, let's do the release. It may also give individuals who feel so motivated the opportunity to go through the land records and do something at the end of it. But it's the idea that over time these collect. And the second part, I think the real benefit of this is that this release becomes a separate indexable document. So if enough people do it, say 10 people in a town do it, and say somebody wants to come in and research these restrictive covenants, did they exist in this town? This gives them actually a very good starting place for such research. And to be clear, none of this will take out any of the existing historic documents. Those historic documents stay in the land records as is. Nothing modifies, nothing removes, nothing changes. They stay in there. But in if one of the goals, as I understood in talking about this with the REIB department when this was being generated was to make sure that there was that record, there was that ability to research, there was that ability to find these. This bill actually nicely it helps that process, because if the releases are filed, and separately indexed, it gives people a starting point for their research.
Senator
And
Bruce has a question.
Dan, I'm just wondering, you mentioned the REIB. In your sense, your discussions with them, do they favor this approach?
So I want to be very clear about this. When I initially was working on a bill with Eric and Representative Grad, I approached the REIB department and the then director, showed her versions of this bill, and one of the things that she was very vocal about and strongly desiring was to make sure that these items were these covenants were preserved, and because I think it sets the foundation for a discussion about and potentially if down the road people want to look into issues of reparations, that was certainly part of the conversation. She had recommended a clause in the bill that was struck in the House at the request of the real estate section and the Bankers Association that would have required deeds to even if you released the deeds, if you found a racially restrictive covenant, you would be required to put into your future deeds basically a verbiage that said this property was once subject to a racially restrictive or religiously restrictive covenant. That language was ultimately struck in the House because of the discussion earlier about Bianchi and clouds on title, and the fear that forcing language into future deeds, creating those type of requirements, create problems potentially for title, and have unintended consequences. So that discussion took place in March, and at that time Director Green had left or was in the process of leaving the REIB department, so we didn't have a follow-up conversation about that removal. But I did understand from my discussion with her that it was very important that this language, the initial language, the initial racial covenants, not be somehow sanitized or removed from the land records, which this bill does not do in any way, shape, or form. This keeps it there. And as I said, I think it allows these releases actually provide that sort of rudimentary beginning type of index for researchers, for individuals or committees looking into this issue. It will help start to build that record of this legacy, and to start to create something researchers can go into a town and find a bit more easily. It's not going to be complete because these covenants sit in deeds, and they sit in deeds at various points, and they don't necessarily have a big headline. That sometimes they're just a simple half of a sentence that's somewhere in a handwritten deed. And sometimes they're more formal, or as Eric pointed out, I think in prior testimony, sometimes they're not even in the deeds themselves, but they're in a document that the deed refers to, a subdivision set of covenants. But this index, this release would I think in some ways do that. But I also want to be clear in sort of answering your question, Senator Baruch, and I apologize for speaking at some length. But if I, in prior testimony, gave the impression that this bill originated in the REIB department, that was not correct. It was an effort on my part to make sure that REIB received credit for being consulted on this. And what I thought was, a generally good bill that helped this discussion and helped this process move, a bit forward. And I wanted to acknowledge that I had consulted with them in the first place. They were supportive of it as of December. They had, Director Green had given me an email saying that she supported the bill. But again, to be clear, it was the bill with the additional clause. in that. And so that's what I represented to this committee.
Thank you.
Good.
So I guess I am a little bit confused about the idea that having some of these releases will make it easier for researchers, because I have no idea in the town of Putney if there were such covenants. There may be and there may not be, but if somebody comes to Putney to do research on it, if they don't find any releases, are they going to assume that there was none? Or if they find 5 releases and then they say, okay, this is 5 releases. And I mean, I guess I don't understand why it would make it easier to do the research, because you're still gonna have to go back and you're gonna have to look at the original deeds, and you're gonna have to look at, if you're doing real research on deeds, you're gonna have to look at all the deeds in the town. So I don't understand. I would end the bill at the middle of the second page on B and just take all that out.
Sure, and that's certainly, I think the most important parts of this bill from a legal sense, and I'll answer your question. I apologize, I'm gonna break it into a couple of different parts because it's a very good question and it has a number of different things. The most important parts of this bill, in my opinion, are the first 2 sections. And that's because there is no law in Vermont making these covenants illegal. There is case law, beginning with Shelley versus Kramer in 1948, that says that the courts will not enforce these covenants. But what's interesting about Shelley versus Kramer and its progeny and the subsequent cases that have enforced this is basically the courts say, they don't say that these covenants are per se illegal or cite a particular statute like courts often do when they say we're not going to enforce this. It simply says that it's against the public policy, that the US government couldn't have these covenants, and that the courts themselves won't be used as mechanisms to enforce something that is against public policy. And so in a lot of ways, that is kind of the end of the story. But I remember first year of law school, when I first read the Shelley versus Kramer case, and then this issue came up, it struck me as anomalous in a lot of ways, because it essentially said, the court said, well, we're not going to help you do this, but it didn't say you can't do this or that this is somehow illegal. And so part of this, most important part of this bill is the first 2 sections that say, with the full power of the legislative and executive branches, these covenants, these type of restrictions are illegal as a matter of law. And I think that's really powerful. But to answer your second question, Senator White, about how this helps, let's take Putney, for example. You go to the land records of the town of Putney and you're saying, as a researcher, are there any of these type of covenants? And what nature are they? Because as we see in a town like Greensboro, there are a number of restrictive covenants, but they're religiously restrictive covenants. If there was a person there who owned land and developed it and put on this restrictive covenant to keep out people of the Jewish faith. If you're in Putney and you're trying to find these covenants, you're not going to have an easy way to find them. What you would probably do is you'd go to certain time periods where it was likely that these covenants arose and start to do some random searches through the land records to try and find them. But it is going to be a little bit of a hunt, because none of these covenants are going to be separately indexed. None of these covenants are going to be collected in any particular way. You might even end up asking the clerk, do you know if any of these deeds have a restrictive covenant in them? And the clerk may or may not know, just through anecdotal evidence. But what these indexes do is that if an individual has a property and they find a restrictive covenant, rather than going, well, that's really too bad, or any other sort of non-response and then move on with their life, it gives them an opportunity to file this release. And say you go to Putney and you find 5 of these releases. Well, that gives you a start. First of all, it tells you that there are probably more than 5 in the land records. You look at those 5 and you say, well, where do they come from? What kind of restrictive covenants are they? Are they religiously restrictive covenants? Are they racially restrictive covenants? Do they date from a certain time period? Because now if you find 5 that all deal with racially restrictive covenants and all date from 1938, well, now you have a starting point for your research. You can look to that era because it's going to be in the bound books in the land records. And 1938 is a book. And you can just flip through, rather than flipping through 100 of these books, you can start at that and then move out, go to 1939, go to 1937, start to build a sensible search. And in that way, it would help. It's not going to help find every single one. And I think anyone going in that found 5 of them said, well, we're done. I don't think any sensible researcher would necessarily stop there, that they would see that as a starting point. Because I think a lot of these towns, and this is what's, I think, challenging about finding these in Vermont, is because they are not separately indexed or classified. If you want to find a mortgage from 1880, it's separately indexed. You can find it.
I appreciate all this, but the real issue is,
Sure.
should we go forward with this bill? We're at the end of our session. And what's the harm if it lasts another year?
Can I ask a question? Because I'm thinking, I don't want to intercede between him answering your question. I've been chomping at the bit ever since.
I'm sorry. What's the harm of this waiting another year?
Senator Sears, if that question for me, there is no harm. And I guess I would say at the end, certainly from Mark Hughes's testimony earlier, what I would say is that there is the legal structure of this, but then there's also the buy-in and how it's received. And so certainly if this committee feels that it's important to study this issue longer, I will certainly be here in support of this bill next year to help it, because I think it's the right thing to do. But if you want to take more time, there's no immediate harm that I can foresee.
Okay. Senator Benning.
Dan, I'm coming back to the question about whether we're overcomplicating this. The entire testimony you just gave about somebody wanting to get a reference point going back in time is completely irrelevant in my eyes if we simply as a society say these are, whether they exist or not on your deed, they are null and void and unenforceable. So here's my personal nightmare. Person is running for a position of any kind in this state, and the opposition doing research stumbles upon a 90-year-old restriction on candidate A's deed chain. If candidate A has not filed a release, that becomes fair game. The other part of the problem is that if you are going through the process of filing a release versus not filing a release, all of a sudden we're dividing up against each other for explanations as to why one has taken that action. And if society's main intent here is simply to declare anything that exists is null and void and unenforceable, why not just stop there? Because there's no purpose in going back in time to find out whether they exist or not. If you've already declared, there's no rational reason to enforce them. I'm just thinking we're overcomplicating this question.
That may be wise counsel. Dan, thank you. I've got about 9 minutes left on this subject. I'd like to give Mark a chance to comment briefly if he could, or if he wants to.
Yeah, Mark Hughes, Reverend Mark Hughes, Racial Equity Executive Director. I am happy to do so. There's a couple issues. I think the most important one is first of all, the false narrative of scarcity with the time. I wish I would have been afforded an opportunity, Mr. Chair, to lay this thing out to you in the way in which Mr. Richardson did. But I'll take your 9 minutes. The challenge that we're working with here is we just haven't had any voices at the table to have a conversation.
Deanne, hold on. When I said brief, we're gonna take this up again. We're not voting on it today, so.
I understand that. The challenge here is, Mr. Chair, is just we just haven't had enough voices in this conversation yet. We haven't. And and what I mean by that is it's just the whole framing of this conversation. There's a lot of ground to cover, and there are a lot of this is a very complicated issue that we're dealing with. So I disagree with the senator who said that we're overcomplicating this. I would say that it's simple if you want to have a homogeneous conversation about this, but if you want to bring more stakeholders to the conversation, the complexities, they begin to multiply. I think that one of the things that we have to take into account, well, first of all, I just want to acknowledge the fact that there are still some discrepancies in terms of the origins of this policy. You will hear from former Director Green. She'll be sending the committee a notice. I talked to her again yesterday, and the conversation that she had with Mr. Attorney Richardson and the exchange that she had with them is in dispute with her former employees right now, because it's being somehow or another characterized as her sign off on a policy as opposed to a specific incident regarding a person who's a Jewish woman who's sitting on the other committee. And it was a specific example. And in fact, that was the origin of the policy. Despite the fact that we have a reparations task force in Burlington that's been waiting for deeds for a year in Burlington. And I reside in Burlington. And the reparations task force was initiated by the work of the Vermont Racial Justice Alliance through the historic Racial Justice Bill on the 29th of June in 2020. So the interest, if there was a vested interest in getting this work done in terms of connecting the dots, if you will, again, for the record, there's a reparations task force in play in Burlington that has been inactive for 8 months. The chair, Hal Colson, just resigned last week, and we've been waiting for records on deeds for over a year. So that is my testimony. That is the background. Those are the facts, and that's the context of how I am entering some of this testimony. One of the things that we're not talking about is the fact that if it's illegal, then what are the consequences? This part of the conversation that some of us want to have that perhaps are not at the table. As an example, Minnesota's regulation here is this is 507.18 in subsection 4. It says there are civil actions, there are damages. Every person who violates that subsection that calls for these deeds to be cleared, that is to say, these conveying the provisions against conveying mortgages, encumbering, or leasing any real estate to any person of a specified religious faith, creed, national origin, race, color, anything in violation of that, there was, or aids or incites it for another to do so, rather, shall be liable for civil action to a person aggrieved in damages of $500. This is just an example because this is one aspect that we're not hearing, and the reason why we're not hearing it is because everybody's not at the conversation yet. I think that the exchange that I had with the executive director of the Human Rights Commission last night was a little bit illuminating. But she certainly has her opinions on this. But I think as we began to unpack it, it became clearer that, yeah, it probably would be a good idea to have some more conversations. I realized the Homeowners Association, Mr. Chair, was present, and I know that there have been some conversations. Perhaps it wasn't the Homeowners Association. However, the point being is I don't see any language in here that has anything to do with the occupants or the tenants of these homes. The occupants and tenants of these homes, I would think, are pretty important. What I have here, and this is just cursory research by a non-legal novice, just pulling up some things just to bring to you to initiate a conversation. But this is a bill that was passed in Washington, and within it, there's language that speaks to the ability for injunctive relief in the courts if a quote, the owner, occupant, or a tenant of the property which is subject to the provision or the homeowners association board may cause the provision to be stricken from public records by bringing the action to superior court. There's no conversation about this aspect either. Now, this is particularly important because you must remember we live in a state where only 24% of Black occupied housing is actually owned by residents, whereas 71.7% of occupied housing is owned by white residents. And in the city of Burlington, 0.2% of Black occupied housing is owned by its residents, and 95.9% owned by whites in the city of Burlington. So there is no provision here that provides for a resident or a occupant or a tenant if they become knowledgeable of this, the existence of this. And the list goes on. There's also the challenge here of, okay, so how do we account for this work that's being done? Because as you know, those of us who are doing the work, say for example, standing up reparations task forces, advocating racial equity and justice, advocating racism as a public health emergency joint resolutions in the state legislature, are concerned about how do we aggregate and correlate this data so we can do the search. Again, in Washington State, as well as in the state of Minnesota, both colleges are highly engaged in this process and have developed heat maps that have time-lapse views. And I would show it if I had more time, but they have time-lapse views of where these covenants and where these deeds actually exist in these neighborhoods to enable us to go back and do the work, because the work it does not end when these deeds are gone. The work never ends, in fact, but there are many policy-making decisions you're going to need to have data to work on, and there's also some things that we're working on. We'll need that data. The reason why the reparations task force asked for the deeds in the first place was this purpose. So they are this apparatus. We could also extend this over into the college. There's nothing in this policy that addresses allocating, or I should say appropriating, any resources that goes toward the research that's needed in this particular work. Nothing. So it goes on. We could go on, and I won't. But to answer some of these questions, why don't we just make this null and void? Because of erasure. Despite what the lawyer tells us here, who's representing the city of Burlington, who, by the way, I'd be happy to have a conversation with after this and at any time in the future, and totally stoked about collaborating with the attorney from Burlington. It would have been nice to make his acquaintance prior to such time. But I live in Burlington. I live at 222 Riverside Avenue, apartment 12 in CHT housing. So this is the position that I'm bringing to this conversation. There are many other folks across the state who probably have other perspectives, because we are not a monolith as Black folks, and I'm not here to speak for all of them. But why does it make it why not just make it null and void? Why is the other documentation necessary? Also within this policy, there's no method where there's no method whereby it is established that these documents that have been called out, by the way, the document is even nondescript itself. It's a certificate of release of certain prohibited covenants. What is that? When you go back and look at that later on in perpetuity, how are we going to be able to determine what it was in the first place? And even if you did, you'd still have to go and find the record. So I categorically, I think, disagree with the fact that this is somehow or another going to make things easier. It is not. So there are a lot of holes that we're working with.
That's a question mark. Could you please? Thank you.
Is there a question?
There is. I'm wondering, Mark, and I know, over the years we've talked about deadlines and how frustrating they are, but again, we're under a deadline. We have 4 days to do something or not with this bill. So I'm just wondering, I hear all of your concerns. My question to you is, would you and your organization prefer that we table the bill, not move it, or that we turn it into a study to allow the conversation that you're talking about?
It's my personal opinion that the bill should be tabled. And I think that as far as, moving forward, I really like to reframe the question. The question is given everything that we know now and where we are, all of us, what do we collectively think is the best route to take? And I don't believe, as a legislator in good conscience, any of you believe that this bill should be moving forward in light of the comments that I've just given you, and in the absence of some of the voices that should be at this table and the concerns that have been expressed, particularly in light of the fact that the person who put it forward said he can wait.
So Mark, may I ask a question?
Yeah, we're gonna stop this I'm already over time here and I've got another bill to take up. So go ahead, Senator White.
So it seems to me that all this bill does is says they're null and void and they're not enforceable. All those covenants. It doesn't go into everything that you've been talking about, but that doesn't mean that can't happen at another time. Shouldn't we just say they're null and void and they can't be enforced? And then move to the next steps next year over the summer. There can be more work on it and look at what you're talking about, but we can do something, or we can try to wrap the whole ball of wax around and do nothing.
Now thank you for the question, Senator. And this is at the heart of the work that we're doing, because the whole conversation is about equity. And what you're asking me is, why can't we just let the bus leave without you today, Mark?
No, that isn't what I asked you.
This whole process, Senator, this is the legislative process. When a bill is opened, that means everybody in Vermont should have the ability, and many people outside of Vermont should have the ability to come into your committees and to offer their perspective on these policies. And as you know, if you make sausage, at the end of the day, it never comes out the way anybody wants it. But what we see here is, because of political and economic power, that is not happening in this particular case. And what you're suggesting is, what we have.
Mark, I don't think anybody was denied the ability to come and testify. If somebody wanted to come and testify, they certainly had the ability to call and ask to testify. Just as in my committee, I welcome everybody, and so does Senator Sears.
You know what? I get notifications from your folks in your committee, and also from Senator Sears' committees, and I'm sure many other folks do. And this is not about who's notified or what, but Senator, please don't try to convince me that this thing wasn't ramrodded through. You've seen the testimony list from House. you've heard the testimony here of this lawyer, and you've seen who showed up to testify for it here. And so I mean, I'm not that right there. What you said, you know, it's kind of backhanded, but I'm not suggesting that anybody didn't do their job. But I'm just saying the gravity of this bill, the nature of the matter that we're dealing with, it deserves more attention. And if this committee can't see that, and if that's not going to be acknowledged, then fine, I'll get up and walk away and come back and fight another day. But I'm not going to sit here and listen to some kind of retort from my testimony so as to suggest that somebody's done their job here and getting everybody who needs to testify on this policy here, because it hasn't happened.
Thank you.
Thank you.
We're going to switch now to H399, an act relating to incarceration terms for criminal defendants who are primary caretakers of dependent children.
Morning, Ben.
I'm gonna step out for a minute, so I'll be right back.
Okay, do you want to keep going?
Yeah.
Okay.
We're actually, everybody likes this bill supposedly.
Okay,
Of course, we thought everybody liked the last
It's
one.
an easy bill.
Okay.
so it's H399, and then you want to give us a quick walkthrough?
Sure. Ben Overgrowski for the Office of Legislative Counsel. Good morning. H399, as outlined in section 1, which is the purpose section of the bill, really proposes to ensure that children with parents, guardians, caretakers, or family members involved in the criminal justice system are considered and not unnecessarily harmed during the sentencing and incarceration of influential people in their lives. This bill attempts to achieve the goal by making small but important changes to sentencing considerations under section 7030 of Title 13 and pre-sentence investigation reports under section 204 of Title 28. I can give an overview of sort of how sentencing plays out and the pre-sentencing investigation, if you'd like.
That'd be great.
Sure. It's important to understand how sentencing plays out in our courts. Generally, after an individual is convicted of a crime, a sentencing hearing is scheduled to provide an opportunity for the parties to address the court and to permit time to conduct a pre-sentence investigation, or PSI for short, if it's ordered. The purpose of a PSI is to create a report to provide the court with information that may be helpful in imposing a sentence, granting probation, or in the correctional treatment of a defendant. The investigation is conducted by the Department of Corrections, and the defendant is interviewed by a probation officer as part of the investigation. The information contained in the resulting report can include any prior criminal record and information on the person's characteristics, financial condition, circumstances affecting the person's behavior, and other information that may be required by the court. The defendant has a right to comment or object to the report or any recommended probation conditions. The parties may present evidence of any disputed fact at the hearing so that the court can make a finding relative to each fact. And in the end, all this information is taken into account when the court imposes a sentence or grants probation. Now, turning to the bill itself, unless there are any questions about the process. Section 1, as I said, it states the purpose of the bill, which is to prevent unnecessary harm to children caused by separation from influential people that incarceration may cause. The bill also helps to ensure the fair and compassionate treatment of children during the sentencing process by providing them with certain basic considerations. Section 2 of the bill is what amends section 7030A of Title 13, which considers sentencing and its alternatives. When making a sentencing determination, section 7030 mandates that a court consider the nature and circumstances of the crime, the history and character of the defendant, the need for treatment, and the risk to self, others, and the community at large. The bill adds language to 7030 that ensures the court considers the defendant's family, circumstances, and relationships and the impact of any sentence upon the defendant's minor children. Section 3 of the bill amends Section 204 of Title 28 concerning the submission of pre-sentence investigation reports. So in addition to the information I previously discussed, H 399 would ensure that the PSI report sets forth information concerning the defendant's custodial relationships and cross-references the sentencing considerations outlined in 13 VSA Section 7030. Essentially, these statutory changes would require the court to consider the defendant's family circumstances and relationship by permitting the defendant to present evidence at sentencing, including written testimony from family and community members, written statements, video, and other forms of documentation. Mandates that the court consider this evidence in its assessment of any alternatives to incarceration so that the community at large is adequately protected with as little impact on the defendant's children as possible. And the bill under Section 4 will take effect on July 1st of this year.
Thank you for the reading of the bill. I decided that unless you all want to hear more testimony, on our website is the support of the state's attorney, support of the defendant general. I don't see this as we already do it actually. So they're just expressing as Evan Meehan points out. Department of State's attorneys do not object to H 399 as passed by the Vermont House of Representatives, because Vermont courts are already permitted to consider the impacts of a sentence on the defendant's family. For example, in State v. Sullivan, the Vermont Supreme Court stated, it is appropriate for the sentencing courts to consider a wide range of factors to determine the sentence. The factors include the nature and circumstances of the crime, the history, character of the defendant, the need for treatment, risks to self, others, and community at large presented by the defendant. They also include, among others, the defendant's background, his family, past conduct, and his propensities, and the defendant's refusal to accept how his actions harm the victim. So that's the Supreme Court. Marshall Paul, they strongly support, the Defender General strongly supports it. The list of sentencing factors requires courts to consider the characteristics of the crime, character of the defendant, defendant's need for treatment, public safety, and the term when sentenced to oppose, not inclusive. Frequently comes up the defendant's family. So I'm not sure the bill is necessary, but
Actually, Mr. Chair, if you're willing to entertain a motion, I'll move that we concur with the House on this. And let me just briefly say that I've seen hundreds of PSIs. We do throw everything at a judge we can from the defense perspective, but this simple addition of language is going to force the judge to raise this particular discussion a little higher in the conversation on what to do with somebody. And that's why I like that provision being there.
So the bottom of the first page at the very bottom, after it says impact of any sentence upon the defendant's minor children, and then the need for treatment. So I understand the need for treatment, but is this leading to, I'm assuming it's leading to that someone pays for the treatment.
That provision is not referring to the previous sentence before the semicolon.
Oh, it has
It's
a
actually
semicolon.
talking about the defendant's need for treatment.
Oh, okay.
you might,
That's what
you could, I suppose, add the word defendant. I don't think it's necessary.
No, because all the things are being looked at from the defendant's point of view, the history and character, the family, their need for treatment. I think it's.
The sentence on the defendant's minor children.
Yeah,
I
I
think
agree
it's fine,
with
yeah.
Joe. I think we should concur.
Okay.
Which bill was this? I didn't know this already happened.
This was, I believe, Representative Coffey, Donnelly, and there was list of others.
I think it came out of the women's talk.
Okay, so that's a lot easier than the other bill.
Shouldn't have been.
All right. Peggy, would you please call, is there any further discussion? Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nicker,
Yes?
Senator White,
Yes.
Senator Burris,
Yes.
Senator Pierce.
Yes. Who'd like to report this?
Scott, Senator Benning.
Senator Benning's written all over it.
Should have mentioned that it's already being done.
It'll just.
Is this one that only has one witness?
Yeah, exactly.
So,
If you'd like the witness list, we can prepare that for you.
I can probably write that down right now. You don't have to worry about
Well, actually, we did, we did consult with both state
right,
attorneys,
they both.
and I believe the court also approved of it, so.
Yeah, at the House, Chief Judge.
So I think it's, say all the usual suspects.
So, can I ask
it. Can you give me the
Ben, while
latest
you're
list from
here.
the House?
Are we gonna end the meeting now, Senator Sears?
I